We are at day 4 of the Sarah Boone trial, and I know a lot of people were disappointed in the prosecution's cross examination yesterday. I guess we're going to see how they do today. I do want to mention if you like the content, like, comment, subscribe. If you want to support the channel, link in the pinned comments. But before we get into the case today, I want to mention something that I saw. I'm going to be honest, I got really busy. I watched the live stream last night, and then I did try to catch up on a little Sarah Boone news. Surviving the Survivor on Twitter tweeted, and I want to quote this: in an unexpected plot twist, multiple sources telling me Sarah Boone's girlfriend is in the gallery. The two reportedly met while in jail. Could explain some of the smiling. Of course, I can't verify that, but that is something. To me, someone who feels like Sarah Boone is the type of person that needs to constantly control another individual, this is the least shocking news in the world that she found someone in jail, right? With that being said, let's get into it. My hand is still killing me, so my notes might be shorter, but I'm going to get as much information to you as I can. The defense called Deputy Ramirez Delgado. She was a backup deputy for the 2018 DV call. Again, if you haven't seen this call, I do have it in my Sarah Boone playlist. I go through the whole thing. There's also a video where I go through the arrest affidavit of the day. This is the call where Sarah Boone got arrested and eventually got charged with third-degree felony strangulation. Sarah had bruising on her eye. George Torres had abrasions and marks on his neck. She detained Sarah Boone. Sarah Boone got asked why she was in trouble. This, of course, is the defense asking leading to these questions. Sarah said she fought back. Defense has no further questions. Now it's the state's turn. The deputies listened to both on the scene, took into account statements, physical observations, scene, demeanor. Yes, released. So basically, the state at this point is just setting up, hey, you took it both into account before you took them in. They both got arrested. There's a lot of stuff today I want to say already. This is before the mid-morning break, I guess, lunch break, whatever you want to call it. This is all before that, and the state, to me, seemed to be setting up for their rebuttal. They seem to be setting up for that, which I know a lot of people are like, I hope the rebuttal is better. Well, let's get into it. Next up is Corporal John Alden. He was a deputy in August 18th, 2018. Sarah Boone had redness on her neck and an old eye injury. And there was an injury to George Torres's left eye. George Torres was placed under arrest, and the defense stopped here. And I thought that was weird. It feels like they don't even it feels like they've maybe already mentioned these witnesses, and because they're state employees, they felt like they had to bring them up. It really felt like the defense was not really doing much here. State's cross. State asked if it is fair to say that George Torres has quite a few marks on him that day, and the detective says he remembers marking the left eye. And the state asked, you had body-worn camera, and that would be the best evidence, correct? And he said yes. George Torres refused to say what happened that day. Yes. They got their conclusion by talking both to them and observing the scene. Released. So to me, maybe I'm wrong. This is the state basically saying, we're going to use that body-worn camera, and we're going to look at those injuries. And it's kind of a precursor. So, sure, George got arrested, but was he covering for Sarah? That's how I feel the state is going to try to swing this. And I wrote down some personal thoughts here. I think this is going really, really fast. I think the body-worn camera mentioned as the best evidence is a hint what the rebuttal is going to include. Okay, so I did put that in my notes. The defense then asked to approach, and they brought back Detective Kepsel. So this is the detective that was on the scene, the detective that did the interview. They asked if she interviewed Abraham Moreno on February 26, 2020. Yes, recorded. He did have contact with her, but when they were there. So he had contact the day of, but later in the day, he said that Sarah Boone made a statement to him. Defense asked if she remembers that statement. Kepsel says she doesn't wish to quote what he stated, but mentions something about being dragged down the stairs a few days prior. Defense says, do you recall him saying he grabbed her by her hair and drug her down the steps? She thinks that the defense is reading her report. The statement was on the 24th, a couple days ago, so potentially that could have been the 22nd. Now remember, there's an argument going on from yesterday. It's a spillover from yesterday. Yesterday, so Sarah Boone stated that the neighbors were wrong and the sound they heard, the banging, the wall shaking, that was actually her being dragged down the steps on the 22nd. And nothing like that happened on the 23rd. But we also know from, Sarah Boone being talked to, she doesn't remember what happened at 11:03 when she took the photo of George in the suitcase. But the banging was about 11. So Sarah admits she doesn't know what happened that day, but it had to be the other day. Nothing saying things didn't happen both days, right? That's what I'm trying to get across. There's no evidence that things didn't happen both days and that these two people are wrong. Did Mr. Moreno indicate that what happened that day? I believe this is the maintenance guy. It was an accident. Sarah Boone was teaching him a lesson and she fell asleep. Detective says she doesn't remember that as accurate. She remembers him saying she passed out. They bring up the detective papers. It's a written out version of her 11-minute interview. Defense wants the detective to read it, and there's an objection, and she can't read it. So the defense can't make her read her statement. Defense asks, is there a reference that she was teaching him a lesson, things got out of hand, and she fell asleep? No to the first two parts. She thought that she passed out, was said originally, because that's what she thought that the defense had said. So sounds like he did say that she had passed out, that she had said she passed out, but the other two parts weren't there. I believe this guy testified day 1 or 2, maybe day 1. And he did say that she wanted to teach him a lesson. That's not in the report. Detective says lesson isn't in it. Out of hand isn't in it. Witness is released. Defense asked to approach. So all of that has some backstory. Basically, they had, I think it was the maintenance guy, went up, spoke to Sarah. He made a claim in his testimony that Sarah said these things and that he told the detective, and his statement in court does not match the detective's written statement that is, I believe, a physical copy of what was said in the video. Now, this is where things get a little wild. Next up is Michael Brannon, psychologist. So we're getting to the doctors. He's been doing mostly forensic psychology since 1994. Psychologists have to continue their education, which includes looking into domestic violence such as battered spouse. He explains what the DSM-5 is and that battered spouse syndrome is not in it. I think this is important because DSM-5 is brought up to back up other things the state is going to say in rebuttal. So remember, battered spouse is not in the DSM-5. It is not a formal diagnosis. He said it would be closest to trauma disorder like PTSD. He's testified for both the state and defense in cases over 1,500 times. The defense asks about a jury instruction, and then there's an approach. So I'm assuming they can't talk about the jury instructions. He names other words for battered spouse syndrome. He's testified in maybe 50 battered spouse syndrome cases. He's hired 50-50 by state and defense. And there's an approach, objection, sustained, and the judge pulls them back again. The objection is still sustained. Defense asks, has battered spouse syndrome been accepted in the Florida court system to your knowledge? Objection, sustained. Explains how battered spouse syndrome works to the jury. Defense tries to mention a bruise on his own nose. So literally the guy speaking, I guess, has a cut on his nose and he tries to talk about it. There's an objection and they just kind of move on. He is asked if a garbage can hurts you, would that cause a psychological response or trauma? And the doctor says you would see the garbage can differently. There has to be something bad that has happened over time, coercive control, and then you have to feel like you can't leave. And they will do things to please the other. That's an explanation of battered spouse. And I wrote a note here, a long note. This could be flipped to Sarah. Sarah was also abusive. She controlled George. He had no phone. She was going through the phone after he used it by her own admission. She wasn't beyond using 911 to get what she wants, as the state put forward. Sarah admits also the strained relationship with his family, limiting where he can go. She was even sending them letters. I could see all of this getting flipped by the state. So at this point, I'm like listening to the doctor, and I'm like, the state could theoretically make the argument that George was a battered spouse. Alcohol, drugs appear from abuser or the abused, deaden the pain sometimes. The abused sometimes defends the abuser, they'll explain away things like a battered eye or someone yelling in the background on a phone. Again, I left a note. I don't know if this part helped Sarah, as we heard today about injuries to George that he wouldn't explain to the police. And also, we have Sarah admitting to screaming in the background of a phone on the night of the murder. Hey, me, that was a good thing to point out. Again, it felt like I know, like obviously, I was like, oh, so this is a guy who I thought maybe had like assessed Sarah at this point, and I thought this is really going to go against her. So let's continue. Rule outs exist for battered spouse. Examples where you have to rule out substance effects. So I don't know why that was brought up. Because they had, like, it makes sense. I guess they're just saying they aren't hiding it. You have to rule out like if substances are involved, if they're the reason there's battering, because then maybe it's not battered spouse. Defense asks about the person suffering, assuming a threat. Others might not. Objection, approach, objection, sustained. They ask if he was approached about doing an assessment of Sarah Boone. Objection, relevance, approach. Objection, sustained. Owens got up to help the defense lawyer at this point, kind of like pointing him on a piece of paper what to say or ask. And they ask how the doctor approaches an assessment. He says he makes sure he is qualified, then he has the time, and then what information is available. And then to me was the bombshell. He has not done an assessment in this case. This man has not assessed Sarah Boone, which explains to me quite a bit, because I was wondering, why is he saying things that in some ways seem to implicate Sarah Boone as possibly this, this negative figure in this. And he hasn't gone over this case from the sounds of it, or at least he hasn't given us an official assessment. The defense asked if it was his choice to not do an assessment in this case. Objection sustained. Maybe he wanted to do it, and maybe he offered himself to the state, and they said no. They had other experts. I don't know. Can battered woman syndrome appear when it involves other family members, two-legged or four? Yes. More people threatened can mean more control. You look at the outside materials when making a diagnosis. You want the facts of the incident, and things others have heard. You want their medical records. Have there been police statements? Want to hear 911 calls. Because the abused person is defending the abuser, it can take some time to break through and get them to talk about the trauma. Look for anxiety, fear, low self-esteem, withdrawal, especially forced withdrawal from family or friends. He explains Stockholm Syndrome. There can be denial of how bad things are. State cross-examination. So, to me, when he's talking about like this forced withdrawal and stuff, I think about the fact that Sarah doesn't have living family. George does, and Sarah constantly talks about how bad they are, how they don't like her, how she sent them a letter about George. It sounds like that she is maybe keeping him away from them somewhat, or keeping them at least at arm's length. She talks about how she doesn't go over there, and when they come over here, there's a problem, that type of stuff. I don't think this is helping Sarah. I'm gonna be honest. I don't think this guy has helped Sarah so far. To me, maybe others disagree. Let me know. Maybe you thought the first half with the defense went well for them. But then we have the state's cross, and the state's cross is something else. They begin with, a couple could be in a 3.5-year relationship with emotional, physical, even sexual violence, and they not view it as trauma. Yes. A homicide detective can see a dead body, and they'll react differently than someone who works at Dunkin' Donuts finding a dead body. The states asks, is it important to get a comprehensive evaluation to get information for what is going on in the perceived battered spouse mind? There's an objection, approach, objection overruled. And they says, yes, relevant information. Would you agree the person accused of committing... So let me stop here for a second. I didn't leave a note. In my mind right now, I think they're setting up that maybe the doctors that did the opinions of Sarah Boone for battered spouse didn't actually have all the information of the case. Therefore, maybe it's not valid. Would you agree the person accused of committing a crime, there are credibility issues you need to care for when their claims of the event? Yes. It is especially important combined with an alcohol abuse disorder. Is this especially important when combined with an alcohol abuse disorder? Yes, it is. Can you explain what it means in the DSM-5? The alcohol abuse disorder can lead to deceitfulness, aggression, unreliability. It must be taken into account when it comes to memory and perception. Now, these aren't, of course, exact quotes. There's a lot of verbiage here. I'm cutting things back. When talking about memory, you want to know how close they took it to a particular event. So basically, if you're drinking when you do the event or just were drinking, that can affect your memory more. You want to know what their recollections are and if it matches up. Remember, Sarah Boone didn't know about the videos until she knew about them, and then she knew about what happened in between, and then she didn't know about the photo, but that photo was at the same time frame she claimed she could remember that nothing went down the stairs. And then they ask a question that I think we were all waiting for. Are you familiar with narcissistic personality disorder? He says yes, recognized in the DSM-5. The person giving a history with even just traits of narcissistic personality disorder, that should be taken into account. So even just a few traits need to be factored in. It has to be taken into account because it can lead to deception or inaccurate information. So they're already playing the game, right? Even if she doesn't have a diagnosis, if she meets some of the criteria, that's important. And now we get the witness listing off criteria for narcissistic personality disorder. Grandiose sense of self-worth, consideration of yourself over anyone else, operating your own world, inflated sense of who you are, a misperception of how important you are and your meaning to other people, a sense of specialness that you stand out from other people with special skill or skills. If other people don't recognize that, they should. An inflated sense of self-esteem and grandiosity. I mean, listen, Sarah Boone sitting in an interview. I mean, Sarah Boone's talking about getting straight A's in school still, as if that, like, she's clinging to anything to make herself seem special, right? The way she talks, the way she acts, the way she wrote those letters, her letters. Please tell me they got an expert and her letters are going to be used to help diagnose traits of narcissistic personality disorder. That would just be what we all expect. That no one's shocked that's being brought up. And the people, remember, the states dealt with Sarah Boone directly, and they feel the same. Explanation of adjustment disorder, which is in the DSM-5, a person's reaction, emotional, behavioral, or both to a situation. For example, you break up and you're worried about the breakup. Maybe you'll stop going to work. Maybe you start fighting with your children. It is considered a temporary reaction. If someone is giving a history to come to a conclusion of battered spouse, if that person has been diagnosed with adjustment disorder before, that event, would you take that into account? And they said you should take all diagnoses into account. Now, I'm trying to read into this a little bit. I'm reading into it a little bit. Maybe Sarah has been diagnosed with adjustment disorder. Maybe she has. Maybe that wasn't brought into account. Hypothetically, if someone says things like, I am the best thing that has ever happened to you and you will never do better, is that a symptom of narcissistic personality disorder? Maybe. When evaluating trauma disorder, how important is it to rule out alcohol-based disorders? Not normally exclusive, but it can lead to misdiagnosis, so it must be taken into account. It is important to take into account the abuser or the abused acts differently in the absence of drug use as well. Yes, because that is a substance abuse disorder. I have a note here. Feels like they plan to use Sarah's statement that George isn't violent when he isn't drunk against Sarah's case. Makes me wonder if they have examples of sober Sarah Boone violence as well. And I do find this interesting, right? So if George is never violent when he's not drunk, George is not a problem when he's not drunk, by Sarah's reasoning, I have to wonder when she's talking, like, she acts like it's impossible to prevent him from drinking. Maybe it's just people I've known that have been alcoholics, but they get violent when they can't, possibly sometimes when they can't get their alcohol. They have a mood to them. She didn't really talk about that, I don't really think, right? She talked about him getting alcohol without her permission, but I don't know. That's, I think, what they're going to go with, right? Are you familiar? I feel like they're going with a lot of things. I feel like they're setting themselves up, right? The state is. Are you familiar with the classic 3-step cycle of battered spouse or domestic violence? Yes, the classic model, which often happens, a period of tense little arguments, maybe some threats or loud voices, Then there's the episode itself. Then there's a honeymoon phase where the person who did the abuse is being nice to the abuse to make up for it. Even one cycle can traumatize a person. It doesn't have to come from a man to woman. That's why it's no longer called battered spouse syndrome. It is now called battered woman syndrome. It's now called battered spouse. Men can suffer. Homosexual couples can suffer. Women are more diagnosed. Maybe they're going to make the argument that Sarah Boone wasn't placating George because of her fear. Maybe she was placating George because she had been abusive and was trying to get on his good side. The trauma doesn't have to be physical or sexual. It can come from emotional violence. Examples can include constant insults to the victim wearing them down. Isolating someone from family, friends, co-workers can be part of battered spouse. Yes. Controlling another person's personal property, such as a birth certificate or identification, being an indication of emotional control that can result in trauma. Yes. If one person gives another partner a gift, but the person who gave the gift keeps claiming ownership of that item, that can be a form of emotional abuse, possibly, but it can also be a control component. So if we are to take this as things that Sarah Boone has done, she's isolated him from friends, family, co-workers. She has taken his birth certificate and identification away from him. And when she gives him a gift, she continues to say it is her item to exert control over it. If that's what we're supposed, if I'm taking away what the state's insinuating here for possible future mention. I really feel like they're going to go with the angle that Sarah Boone is a narcissistic abuser taking advantage of a man, possibly controlling him with alcohol. When one intimate partner does these hypothetical, emotional, non-violent things, if the other partner has poor coping skills and is consuming alcohol, it is unreasonable or unfathomable to think the other partner respond with physical violence. So objection, assuming facts, not evidence, sustained. Then there's an approach, and after the argument, the counsel, the objection is overruled. So basically they're saying all those things we just said that weren't violent, could that lead to someone they were emotional? Could that lead to someone responding with violence? And it said it would increase the probability of physical violence was the decision. It's about whether the recipient views it as trauma and it sticks with them. Anxiety, low self-esteem, depression can be components of battered spouse syndrome. It needs to be ruled out if these existed before the relationship. If it already existed, you wouldn't attribute them to the abuse. Abuse can make it worse, but you need to know where things started. So it sounds like they're going to argue, maybe they have the medical records, that Sarah Boone was diagnosed with anxiety, low self-esteem, and depression before George was around. Independent of any narcissistic personality traits, would you agree anybody in a certain legal setting has a motivation to present themselves in a certain way? Yes, they may do impression management and try to change how they are perceived. The state is down and the defense is now up. You indicated where an individual's credibility may be in question, there is a necessity that whoever is making the assessment corroborate what is said. Yes. Is all of the evidence consistent? You can't rely on just the self-report. So basically they're saying you have to go and look into everything. Is it true people can exhibit one or two parts of a DSM diagnosis but not qualify simply because it isn't there? Yes. So I may exhibit a few qualifications for narcissism but not qualify because I don't meet all of those or a significant amount of indicators. Yes. The defense is arguing that while Sarah Boone might be narcissistic and have those traits, she might not qualify for narcissistic personality disorder. If your defense, the defense is like, she meets all these. What do we do? What do we do? And they're just like, well, she doesn't meet all of them. Maybe if she meets it doesn't mean she gets it. I don't think that's good for Sarah Boone. I don't think she's gonna like that. I think she's gonna be mad at her lawyers. Or it could be situationally based. Have you learned what? So basically, they were saying that maybe they only exhibit narcissistic personality in certain instances. That's not the case with Sarah Boone, right? Like Sarah Boone acts narcissistic in court, acts narcissistic on the 911 call, acts narcissistic in the interview, acts narcissistic with George, acts narcissistic on body cam. She, it's everything, right? I'm trying to find an instance where she didn't act like she thought she was superior to everyone. I really can't. Have you ever learned whether abusive behavior may begin based on things that have happened to an individual as a child, such as they grew up in an abusive household? Objection, not in evidence sustained. So Sarah Boone was talking about having like a good family life, right? And now her family's abusive. See, I think the jury's gonna remember that, right? I think the jury's gonna remember that. She talked about her family. It was so sad when they died, but now they're abusive, or at least it's being insinuated. There are things that may add to or contribute to a particular psychosis or symptom. Would someone's background as a child be part of that? Yes. One symptom not discussed was learned helplessness. Helplessness. Can you talk about that? When someone gives up and feels there is nothing they can do to change their situation, they feel no matter what strategy it won't work, or at least pleasing and apologizing. The doctor is excused. Parties approach mid-morning break. So that's the first part. Now, it feels like it's going so fast. I apologize if I didn't cover it well. I tried. My hand's still hurting, and I'm trying to get all the information I can. I'm also trying to. I want to get notes as I thought as I go through, like what's going through my head. I will say, when it came to the narcissism thing, when they were talking before that about possible symptoms or whatever, in the DSM-5, my mind went to narcissism, and before I could type, they were talking about narcissism, right? I think this is the state setting themselves up for a crazy rebuttal. And if I were the defense right now, I would be extremely worried about witnesses going forward. The state feels a lot more in control this time to me. The state feels like they have a plan. They know what their plan's going to be, and they are executing it. I think that I would not be shocked if the defense just start cutting people, right? So it was in a chat of one of my previous videos. That woman who wanted to appear by Zoom and she had a caretaker and all that. I think we found her, and she was a woman who did an interview about the demons in control of them because of the alcohol. Like, are they even going to bring her up? Or are they going to start cutting people? I would not be shocked if the defense has to start cutting people, cutting witnesses, out of fear of what else they might say that could bury Sarah. But as I said, this is all just before that lunch break. That's where I'm at. We'll see. My opinion can change. I think the defense needs to go on the defensive. I think they need to be very conservative with what they do. And they need to hope. How do I want to put this? They need to get battered spouse out there, the basic ideas of it, and hope that their witnesses don't talk themselves out of that diagnosis. That's my thought. So I do want to begin off with the background because I don't think I mentioned it in the last video. This is a filing from today. Basically, Sarah Boone can't afford anything, and the authorizations of her being able to pay for investigator services. I need something in the background. This was filed at 9:37 a.m. today, or e-filed at least. So there are some new things being filed. I do check. There's just been nothing I felt was worth bringing up on the video here. If I missed something, let me know. But I guess it wasn't lunch. They're back quick. I guess it was just a mid-morning break. Defense calls the person who did the phone extraction. I'm going to butcher this name. I'm sorry about it. Jillian Wadden. Sorry if I mispronounced. She's been up before. She's the digital forensic examiner that, took the phone evidence. Defense approaches with a CD she recognizes is from the Sarah Boone phone extraction. Another CD introduced into evidence, and then we get a video on the TV. It is George very quickly at the start pointing a bat at Sarah, saying, "You're going to help me take this shit out." And it shows the TV what looks like a single bat mark on it, and it ends. Next is a video of him hitting the TV, and it ends. Witness release. And I'm sitting there going, what? My notes are, when we only saw the pictures before, I believed I said that I wanted to see the video to disprove it or prove it. I wanted to know it wasn't him just bashing a broken TV for fun, as some people have been known to do. I've known people to bash up their broken TVs, or the TV stops working, it doesn't fix, and they'll hit it, and then they'll accidentally, it's not working, and they're like, well, screw it, I'll break it up because it's fun. People do it. I don't know why. And Sarah, though, had said he had been making threats and made her record it, and the TV was smashed due to Brian Boone helping with a fire stick. And the thing is, at the end of the day, no evidence was included in those video clips proving anything other than he hit the TV with a bat. For all we know, before, when he said, you're going to help me take this shit out, before that, maybe Sarah Boone, for whatever reason, maybe they're drinking and like, I want to see you hit it with a bat, and he, you have to help me take it out. The photo of him passed out in like afterwards holding a bat that was supposed to be, I believe, also from the videos was not shown, which makes me wonder if there's more video that the defense chose not to show and why they wouldn't do that. Approach the bench. Now it's lunch because the defense does not have a witness ready. They don't have their witness there. Now it's lunch. And I'm kind of in awe. I'm going to be honest. Shouldn't the, how do I even want to put this? Shouldn't the defense have known that and maybe not made them, if there's only one more witness that short, should they have maybe like let the judge know, finish it, and then do the break? Maybe I'm the crazy one. But I wonder if the defense, it said they were scheduled for one or something, I think. Makes me wonder if they thought maybe they were there and they weren't. I don't know. At this point, I'm just assuming incompetence from the defense. Sorry. There's way too many objections. They seem way too confused about the law. They seem to be way too confused with each other. Maybe there's just too many cooks, right? Sarah's got a bunch of lawyers. Actually, I think there's a document about that. Hold on. Yes. Yes, there is. That's a good thing to cover, actually. I had this in another tab. So this is actually from 1021. State's request for an in-camera hearing regarding financial arrangements between the defendant and defense team. So comes now the state of Florida by and through the undersigned assistant state attorney, and states alleged as follows. The defendant is indigent. She has several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving cost money from JAC because of her indigency. Apparently, only investigator Billy Lane is being paid with JAC money. Defendant has secured services of 4 attorneys and a jury trial consultant, and perhaps more people the state is unaware of at this time. The defense team is expending a tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for a several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida, and then traveled back after it passed, incurring additional costs. The state is concerned about a potential conflict of interest between the defendant and her team. Rules regulating Florida Bar 4-1.8b. The only way for the court to know if there's an actual conflict of interest rather than a potential conflict of interest is to review the financial arrangements between the defendant and her team. If there's an actual conflict, the defendant can waive the right with a clear, unequivocal, unambiguous language. For a waiver to be valid, the record must show the defendant was aware of the conflict of interest, the defendant realized the conflict could affect the defense, and the defendant knew of the right to obtain other counsel. The state is requesting to conduct an in-camera examination of the financial arrangement to ensure there is no actual conflict of interest, and if there is an actual conflict of interest, the defendant validly waives an actual conflict of interest. So, as the mention of her multiple, too many cooks in the kitchen thing, the state had questions as well. This is on the 21st, and I don't know how or if this was resolved. I'm going to assume that they're all there, so it got resolved in some way. If that changes and I learn it wasn't resolved, I guess I'll do a video if there's like an updated post about it. I completely forgot about this. I had it open. That's interesting, right? I mean, what's the incentive for all these people? What's their financial incentive? It's costing them a lot of money. Why are they doing it? Goodness of their heart? For the appearances they hope to have in the future on a Netflix documentary? I don't know. We come back with multiple approaches and an issue from a defense witness. Surprise, surprise. Owens has to leave to tell her to be there by 1:30. Now, before I talk about the next witness, I want to read the motion about that witness behind me. So this says, comes now James Owens, counsel for defendant Sarah Boone, and requests this court to grant a Zoom appearance by defense witness Pearl Walker at the trial of this matter, and as grounds would state, the above matter is scheduled for a 2 to 3 week trial that began October 14th, 2024, before Honorable Michael Kranick in Orlando, Florida. Defense witness Pearl Walker is 81 years old and resides in Ovaldo, I don't know how to pronounce that, Ovaldo, Florida. Miss Walker has experienced the death of several loved ones in the past year, which has affected her health as well as having mobility issues due to her advanced age and problems with her knees. The nature of the witness's testimony is important and necessary to the defendant receiving a fair trial in this matter. Defendant requests that her witness Pearl Walker be allowed to appear via Zoom from that location in Florida. Now, here's the thing. We learned in court that when this was brought up in court, the witness was physically in the courthouse that day. And they ended up saying, well, obviously she can be here because she is here and she's next. But that witness, if you looked her up, there's a quote from an article from February 26, 2020. So this is 2 days after the killing. Quote, that was the devil's work to me. She also said, drinking and playing hide and go seek, that's the devil's work. So that's the witness, right? And they bring her in. And she's in a wheelchair, and they have to help her up, and it's I don't know the word I want to use. It is a kind of a spectacle to the jury, right? Like, this is different. This is something different. I'll get more about Zoom in a bit. She's asked if she knows Sarah Boone. Yes, she lived in the same apartment complex as Sarah Boone for about 4 years. They would see her walking her dog walking her 2 dogs, and they would call her over. They would say, "Hey, Sarah, how are you doing?" She would spend time speaking with Sarah Boone. Maybe 15, 20 minutes. Her husband would just say hi. So it was the wife talking. It was Pearl. She would sometimes see it looked like she was choked around her neck or a mark on her arm. Would she say how that happened? Objection. Sustained. When asked about those injuries, what would she say? She would, and before they get stopped, there was an objection sustained. Pearl said, just one of those days or something. That got objected and sustained. She would have emotion. She was upset about something. Would you ask her why she was upset? Yes. How frequently would that occur? On the weekends when I saw her, it seemed to be like a miscommunication. She seemed to think they were like, when did you see her? Not how often was she injured, but she also only saw her on weekends. She does not live there anymore at the apartment complex. It's been a while. How did Sarah treat you? Objection. Relevance. It got overruled. She was nice to me. Did she act uppity? Objection. Overruled. Did she look down on you and treat you with disrespect? Objection. Sustained. Approach. Now, I know what they're trying to do here, right? They're trying to put that Sarah was actually a nice person, so she wasn't what we've all seen. You know what I mean? I don't know a better way to put it. I do. They're trying to get on the record that Sarah Boone is not a cunt. Because she's coming off as one to the jury, to the gallery, to the internet, to friends and family, to everyone, right? They're trying to get a good character witness. And they found it in an old woman. This woman is 81 years old. This woman was old when she knew Sarah Boone. This was a neighbor she passed by. Why would she be rude to an old woman? Even if Sarah Boone is rude and mean and violent to other people, like the least likely, if you were to say, it would be this woman. Maybe they're trying to portray Pearl Walker is black. Maybe they're trying to say she's not racist, but no one's accusing her of being racist, right? As far as I'm aware. So they're trying to get a character witness. So it got an objection sustained. Approach. After a long approach, the objection was sustained, right? So this whole thing about how she treated her is out the window, and I think that was the whole point. I think this was the whole point. I think this was supposed to be a rehabilitation of Sarah Boone's image more than anything. And it's not happening. She said she saw law enforcement a couple times at the complex. She was never approached by law enforcement. She can't say if Sarah Boone was ever under the influence of alcohol when she saw her. She didn't see George much. She didn't know him well. She saw Sarah Boone with a black eye. She was asked if she witnessed patterns showing patterns, was something about patterns of abuse showing, and it was an objection sustained. She said she saw Sarah with a black eye. She was asked, was there any pattern in regards to the injuries and the bruises she saw? I guess it's their way of getting around trying to put forward a pattern of abuse. She said she saw a black eye, and one time it looked like she was choked. Did Sarah Boone ever complain about those injuries to you? Yes, and now it's the state. So that was the whole defense, right? And I really think they wanted to just do character witness type thing. They wanted this old woman to come in and make Sarah Boone sound good, and they didn't really get to do it. Now, she gets asked, when did you see these injuries? That's kind of important, like, do you know when exactly? And the answer is no. This old woman does not know the month, doesn't know when. She saw them at some point. This is years ago. She's old. Her memory is not going to remember, oh yeah, I saw that injury on August 18th, right? Stuff like that's not going to happen, which is a problem, which is why I also think the defense knew that, and this was about character. She's asked, she asked if she knew how Sarah Boone got those marks, like actually knew. She's kind of like, did she see it? Did she know for sure? And she starts a story about dogs barking, so they must have had an argument, and they're trying to tell her it's a yes or no, but it gets out, right? So since it got out, they ask her where she lived, 5 doors down. Now, so the neighbors next door, right? No, she got released at this point. So the neighbors next door must be wrong that they heard a sound that night that corroborates to the same time that Sarah Boone was taking a photo of a suitcase with George Torres in it in the living room, right? But an old woman who can barely hear the defense's questions, who lived 5 doors down, was the best witness Sarah Boone could get. They made this old woman in a wheelchair come in physically. And I understand. The Zoom request here, they gave a reason. I think it was partly so the jury wouldn't hold it against Sarah that they made an old woman who knew nothing to come in a wheelchair physically and have this nothingness testimony. I think this hurts Sarah. I think it hurts Sarah because if you're someone on the jury, if you feel for the old woman, right? You like, you have a soft spot for older people. Does this help Sarah? I don't think so. I think this feels almost, I'm going to say it feels abusive to an old woman. That's my opinion. Maybe you disagree. It felt wrong. It felt bad. Sarah Boone's defense knew what they were getting. They should have known about the objections. They're lawyers. I didn't like it. Owen comes in front of the courtroom. He's walking from the back. He's sounding sad, asking to approach. It's 1:30, and I was guessing his witness didn't show. Guess what? Witness is late. Maybe they're in the security line. I'm assuming that means maybe he couldn't contact them because I'm assuming the security line, you may have to take everything out of your pockets. They can't answer his phone call, whatever. They're off the record. Until the witness arrives, we are back. And I believe this is the longest segment I have ever done. So I'm just warning you, if you need a drink, please go ahead and get it. It's going to be long. I'm going to do the best I can. By the end of it, my fingers were back to aching. And, we're going to hopefully get through it without me having to cough too much or anything like that. We're back. First thing we hear is the judge saying state. The state is saying there's an issue with cameras. Cameras are showing attorneys' laptops, and the state wants it ordered for them to stop doing that, basically. The gallery is asked to avoid that as best as possible. It's protected. Try to avoid looking at the laptops on the table and podiums if you're using a camera. Back on record. Jury brought in Dr. Harper. Dr. Harper is called up. She is a licensed psychologist. She explains her expertise. She's been licensed for 22 years. People previously have talked about how like the blood expert lost the jury. I want to explain real quick. This woman is long-winded. Her explanation of just her history, I know she's trying to make a point, was insane to me. It was too much. It felt like she was going into too many fine details, and I'm sure the jury was tuned out at some point, just waiting for the actual part to start. But she travels the state to do assessments now. She was testifying in a death penalty case yesterday. She just got here last night. Lists some counties she testified in. She has to travel for work. Owens then repeats the forensic work she does, and then she goes off with a full explanation of what she does again. Most of her work is state funded. It gets kind of interesting here. But 95% of the time she testifies for the defense, either side can call her. A forensic psychologist evaluation is different than a normal psychological evaluation because the aim is different. The aim is to answer a legal question so she can educate the judge or the jury when it comes to competency, things like that. That's kind of the core of that. I wrote a lot more, but I don't think I need all those words, kind of like she didn't need all of those. We know what it is. She's done more than 4,000 forensic psychological evaluations. She's qualified to testify in court. No matter what side hires her, it's no different. It's an objective assessment answering a question. There are cases where she evaluates and doesn't testify. Many times it happens. She recognizes Sarah Boone. She got involved with Sarah Boone in June of 2020. First time she heard of the case, she was asked to do a comprehensive psychological evaluation in Sarah Boone's case. She received the evidence, and it's standard procedure, all of this. She received things like witness statements, possibly body cam footage. The state's going to like narrow down what she actually saw, but basically she could have seen interrogation videos, legal descriptions, educational, hospital records, but she was given all the material she was given. She met with Sarah Boone a total of 9 times. They did a clinical forensic evaluation. They talked about her earliest childhood, the 3 psychological tests, prior mental health records, interrogation video, her prior arrest history, and reviewed the transcript of the interrogation. She considered some medical records of Sarah Boone and considered records from George Torres. She considered the upbringing in the assessment, found it pertinent that she was raised. There's an objection, an approach, and the objection is sustained. Would you have considered that members of her family had passed away early in her life? Objection, leading, sustained. She would consider the full family history. She considered the relationship with her mother. She believes Sarah Boone has some narcissistic traits. And I was a little harsh last segment. I realize people are probably mad at my word choice, but I don't know a better way to describe how people perceive Sarah Boone, how people talk about Sarah Boone that gets it across. There's something off about this woman in a bad way, and that's what most of the public feels. And I think it's becoming more and more apparent during the trial that they're worried the jury is going to feel that as well, and they need to come up with an explanation. Owen asked but says she doesn't meet the diagnosis or criteria for the diagnosis. Expert says she didn't diagnose Sarah with narcissistic personality disorder. They asked her to elaborate on why she thinks she has narcissistic traits. An example is Sarah kept describing herself as a straight A student. She kept reiterating her accomplishments, and the woman brought the DSM-5 with her. Owens asked kind of a mashup question about prior witness mentioning grandiosity and narcissistic personality disorder. She starts to answer there's a criteria in narcissistic personality disorder, but then Owens just interrupts her mid-answer. Many times you may have seen these traits and just suffer from low self-esteem, and she said yes. According to the DSM, low self-esteem might make someone act grandiose to feel better. She starts to say why she didn't diagnose Sarah with it, but then Owens interrupted her again to mention traits. First, do they have criteria? Do those have criteria that also match something else? And it happened in this case. She did not diagnose Sarah with narcissism. She said because there isn't a pervasive pattern. Secondly, because the DSM guides you that you should consider PTSD. Yes, you heard that right. They have to go with PTSD. We kind of knew this was coming, right? Because battered spouse is supposed to be part of PTSD. The issue is, I do wonder if some people are going to look at Sarah, compare her to example of what PTSD in their head is like a soldier, which there'll be more soldier comparisons later. And I don't know how the jury will react to this. Now, remember, there is a woman on the jury who is a survivor of domestic violence. So things are up in the air, right? Sarah was diagnosed with PTSD and post-traumatic stress disorder. Sarah did not have much family support. You administer psychological testing to see the difference from an average to assist that person in good effort and aren't exaggerating. So basically, you have to check her for averages to make sure she isn't exaggerating or minimizing symptoms. They did a test to make sure she was validly participating and understanding the legal process. She did, and that she's validly participating in the mental assessment. I might shorten some of these as I read them. Talk about PTSD scale. It sees if trauma leads to a change in behavior. Results were consistent with the person having PTSD. This testing would determine if she had a difference from before the trauma, and the trauma in this case was intra-partner violence. So the argument is that George Torres gave her PTSD. She considers things reported in arrest narratives, witness statements, medical records, and data points. She reviewed Sarah Boone's previous diagnoses and took them into account. They ask what Sarah Boone was previously diagnosed with. Objection approach. And I have a note here. At this moment, I reflected on the fact that the defense has also, the defense so far has given us a witness that has never met Sarah Boone, an old woman in a wheelchair with nothing to help, has had nothing to say to help Sarah, and a doctor that says while she has narcissistic traits, the doctor thinks PTSD is the real diagnosis. I also reflect again that this doctor is very long-winded. Objection was sustained. Owens is confused how to ask the question. He said it himself. Witnesses, she said the witness would review what other experts had previously said. She diagnosed Sarah Boone with PTSD at the time of the offense. She had depression and alcohol abuse disorder. Owens asked the expert if anything she wants to say about PTSD. Expert says Sarah specifically mentioned the time she was stabbed. Objection sustained. Owens again seemed confused what to do. I think Owens wasn't expecting any objections here, and I think that they're getting sustained is really messing with their flow. You have seen exhibits involving her being stabbed. She says she believes some things in common. What is this here? She saw the physical scar, so she saw it, and she saw the talk of it, the physical scar. Objection overruled. She saw some of the things in comments. Oh, so she saw some medical records, but she doesn't know exactly what was shown during the trial, so she thinks she's seen what everyone else has seen, probably. The objection was hearsay, and it was denied. Owens again is asking for more information about PTSD and if it involves more than one event. The expert says that it's the after effects of a very significant stressor or cumulative stressor. The change can include hypervigilance, easily startled, trouble sleeping, changes in mood, irritability, difficulty relating to others. Owens asked trouble sleeping. Yes, Owens asked about sleep deprivation. It is associated with nightmares. And at this point, I kind of was like, are they going to claim she was so tired she killed him and it's due to sleep deprivation? That would be a weird choice. Owens asked her to explain depression, persistent sad mood, hopelessness, sadness, sleeping problems, lack of appetite, or I guess my average day. Sarah suffered from that at the time of the offense. Owens asked for explanation of alcohol abuse disorder. Layman's terms, it's alcoholism. It's renamed. Drink too much and it has consequences. Owen says alcoholism can involve how much you drink and how often. Yes. Owen says people don't know how to put this, or he doesn't know how to put this. So again, he's having issues with the question. Are people who suffer from alcohol abuse disorder in denial? She said it would be one of the stages of it. You wouldn't say you have a problem so you can keep having access to the alcohol. That makes sense. Difference between traits and diagnoses. Traits are things to do, but it means you don't have a disorder because you would have it be pervasive. So just because you have traits doesn't mean it's pervasive and you have a diagnosis from those traits. If you have like a trait of something and there's like a restraint, like it's very specific, it doesn't mean you have the diagnosis, basically. A lot of this gets reiterated over and over because remember, they have to explain this to the jury. Difference between traits and I'll cover that. Repeated domestic violence can mean you are diagnosed with battered spouse syndrome. That would be a PTSD diagnosis. It would be under a self-defense because their fear is based on a pattern between them and their partner. Not the average person would see it. Owens talks about the three phases: tension building phase, change in tone, difference in aggression. Second is the battering offense, the violence. And third is the honeymoon, trying to keep the victim from leaving the relationship. Is alcohol often involved in abuse? Yes. Is a victim in the honeymoon phase thinking it will be better? Yes, in hopefulness to maintain the relationship. Would someone exposed to intimate partner violence perceive the onset of more violence differently than a normal person? It is due to the pattern. It could change in tone. A lot of mention of tone in this, you'll notice. But it has preceded other violent acts in the past. It could be like your partner putting on a different set of clothes to stay home instead of going out, and those clothes have preceded violence before. I don't think that's a good argument. I'm not good argument. Let me rephrase that. I don't think that's a good example, because in this case, they're arguing that Sarah saw something and that made her fear of future violence, right? I think that's clear. I don't think, I mean, it makes sense in this case of how little they have to go off of with what he did. He's in a suitcase, but saying someone changed clothes could be an example. Like, would you say that if someone changed clothes and the partner thought that would mean violence and they killed them, that's okay? I think it doesn't. I think it's not a good comparison for this case when you're trying to build it up for Sarah to a jury. I don't know how else to put it. I don't like it. I don't think it helps her. And I'm trying to think. The whole time I'm trying to think, like, if I was on the jury, I only know this much. What am I thinking? Battered spouse is a subset of PTSD. And when would those changes occur? It would be due to the pattern. You can diagnose it from the pattern of reactive symptoms. It is the expert's opinion Sarah was suffering from battered spouse on the day of the incident. You would have a heightened sense of when danger might occur. Talk of placating the abuser, trying to calm them, keep them in phase one longer, distraction, change of scenery, or substance abuse. Are her words her power? Her words are the weapon she has. I'm gonna be real honest. The realest I've ever been. They said that. I paused the stream and I just thought, no, her weapon is a bat, a baseball bat. And her hands when she choked him before. When Sarah Boone is stressed, she becomes short in her tone, sharper words, a strain. That's how she would respond to Mr. Torres. That are trying to come up with a way, like, why she sounds the way she does. In all these, everything, right? Victims can show a range of symptoms when suffering intimate partner violence. Yes. Self-isolation. Yes. Suicidal thoughts. Yes. Substance abuse. Yes. Bruising. Yes. Chronic fatigue. Yes. Learned helplessness. Yes. She's explaining what learned helplessness is. You learn nothing will change no matter what you do, which is fine. I get that. It makes sense. You're arguing that, like, that you're trapped. You think you're trapped and nothing you do will ever change it, right? I get that. She tries to say it originates from an animal study. I think that is the worst possible thing she could have done. She talked about shocking dogs. From an animal lover's perspective, there's been people that do not like animals being used in tests like this, and it's just abusive, and they don't believe it actually correlates to people. These are animals instead. It takes one of those on the jury to just hate that this woman is quoting this, right? I don't like it. She's the expert. She testifies all the time. Maybe I'm wrong. I've just seen people make statements about similar things before. They don't like it. Maybe none of those people are on the jury. That's what the jury questions are for, right? Intrusive memory, but also at the same time, don't they want animal lovers on the jury because the defense has been saying he abused the dogs? Intrusive memories are you don't want to think about a past traumatic events, but it just pops up in your head. It's a possible symptom of battered spouse syndrome. Triggers can bring on those memories. You can have denial. You're in the middle of this cycle. There's an element of pleasure, something early on that binds you, and you're hoping for that again. You want elements of the honeymoon phase. It's like denial. It is typical for victims to not reveal to others what is happening, so it feels like denial. Denial in public of private issues you are having. It's embarrassing. Revealing is a loss of control. Revealing things aren't perfect. You might be told to leave, and you already know that you don't want it said to you. They are minimizing and numbing their emotions. Do some people disassociate? Objection, relevance, approach, overruled. Some women detach from their body during abuse. They experience flashbacks to past events. Yes. Hypervigilance. Yes. Panic attacks, sometimes present, depends. Low self-esteem. Yes. Poor body image, sometimes. Feeling of no control. Yes. Sexual dysfunction, sometimes. Short-term memory problems and confusion can be. Can have physical problems. Yes. Fear, constant fear. Yes. Part of the abuse would be hitting, kicking, punching, choking, burning, and biting. Objection, relevance, approach, and they say he may proceed. He's asking about common things that might occur with the victim to create this syndrome. He lists things we've from before, using weapons, yes, knife, yes, curtain rod, yes, threatening to hurt you, children, pets, or belittling, humiliating you, yes, taking car keys, yes, control, money, yes, controlling who you would like to see, control where you would go, yes, yes, control who you would talk to, yes, force you to have sex, yes, stalking, yes, slapping you, correct. Victims suffer anger. While she is saying this, Owens kind of interrupts her to keep going. She tries to expand. He loves to interrupt this woman. I think he's realized she's too long-winded too. So some of it is him trying to push her, right? Because you don't want to lose the jury if they're still there. Sadness, yes. Hopelessness, yes. Intense feelings of fear, yes. Abusers have a tendency for low self-esteem or low self-image, something like that. I don't remember what I typed exactly. Objection, overruled. They have a desire for power or control. They have a tendency to use alcohol or drugs. Abusers can have a temper, become jealous, can be. Owens, during this, is flipping through his notes. He's doing that with all these times he lists off problems. He's got notes. He knows what he wants to say. Victims can suffer from severe psychological distress. Is that what Sarah Boone suffered from? Yes. Owens gets some photos, takes them up to the doctor. Did she watch the video of the TV? Yes. Considered it in her analysis? Yeah. Shows her photos of Sarah's injuries, the ones we previously saw at trial. Nothing new was introduced. Is it fair to say it takes a number of visits to build trust? Yes. Traumatized people are slow to build trust. Will they often lie about it? They'll deny it. Sometimes you'll request from an attorney will have Sometimes you'll get a request from an attorney who has problems dealing with a client due to their trauma. Is 9 visits enough? Yes, and Owens is done. So give me 1 second to cough. I saw a comment on my last video about if my coughing was because I vape normally, and the answer is no. I don't vape or smoke. I just kind of am congested and not feeling good, to be honest. And I think the long days, getting up and covering all of this, writing it out, recording it, constantly talking, I don't think it's helping. Be honest. But now it's time for the cross. This is going to be interesting. So you have done some evaluation work on battered spouse for the prosecution in the past? No. So they're making it clear this is just a defense thing she's worked in the past. She has experience working for the prosecution, not for this. Have you done insanity evaluations for the prosecution in the past? I've been called on that in the past. So you understand the government obtains a court order for its one evaluation, correct? She says, I believe you're saying the government can obtain their own expert, correct? And he says, no, ma'am. I am going through, you said you had 9 visits with Miss Boone, over 8 months. What we are trying to have the jury understand is that working for the government, you get 1 visit. She says, no. We sometimes request more visits if they can't evaluate it fully in the first visit, specifically when it comes to affirmative defense such as battered spouse or insanity. And at this point, either the witness is confused or acting confused. Owen says objection. The judge says legal grounds. Owen starts to restate the questions, and the judge says approach. At this point, I noticed the suitcase, the blue suitcase that George Torres was in. I have to imagine this is planned. It is poking out of the box. Like, you can see it. You can see it from the jury. Feel like I had to say that. Objection sustained. When it comes to an affirmative defense, such as battered spouse syndrome, used as an affirmative defense, or insanity, it requires a court order for an evaluator to go. Yes? Yes. What are the agreed upon criteria for battered spouse syndrome? You would see if they are suffering from a mental disorder, and is it in response to a violent act? Do they perceive a threat due to a pattern of violence? Does control over a person have anything to do with it? It can. Does isolation have anything to do with it? Yes. Control, you mean like when they control who you can hang out with? Yes. Can it include personal items? Yes. And you can see that the state is spinning the wheels. Maybe George was the battered spouse, and the person who was the battered spouse is the one who was murdered. You can feel that welling up. When you pull up narcissistic personality disorder in the DSM-5, it has 9 criteria, and you say 5 must be met to make a diagnosis, correct? Yes. Battered spouse is not recognized by the DSM-5, correct? You wouldn't use it as a diagnosis. Is it written down somewhere or a list of criteria everyone else in your field would use as like a recipe? There is no standardized approach you must follow, no statute. It doesn't exist like that. There is no statute directing it. And this is where you make this defense really doubted in the minds of the jury, because as much as they focus on criteria in statutes, at the end of the day, battered spouse doesn't have that. Where does it list these 9 things? Nowhere does it list, for example, there are 9 things these 5 must exist for with examples, correct? So basically they're comparing it to the narcissistic personality. There's nothing like that for battered spouse. This kind of abuse can come in emotional or mental abuse, aside from physical and sexual abuse. If someone responds to what is happening to them, it may or may not be traumatic for them. 2 people can be in a 3.5-year relationship with physical violence and never be traumatized. Yes. A man could be subjected to this sort of violence as well, correct? That is right. It is unique to each relationship. Yes. Trauma is in the eye of the beholder. The person who experienced decides if it's trauma. She said partly agree because some of it is behavioral. She gives an example of soldiers giving outward manifestations of trauma they don't notice. A homicide detective can walk away after seeing a dead body without seeing trauma, while someone else might have trauma. Correct. But she also adds, first dead body is in your memory, but when you become accustomed to it, it's your job. But that's also not part of an intimate relationship. Are PTSD setting off a soldier with are fireworks setting off a soldier or something like that? It was fireworks or something like that. Setting off a soldier with PTSD common because it reminds them of acts of war. That's right. You aren't suggesting to the jury today that someone who returns with PTSD from service is justified to just go outside shooting bullets if they hear fireworks, correct? Something like that. And the answer was no. That's not what I said. And he says, I'm not saying you did. Basically, they're saying, look, even if she has this trauma, it doesn't justify it, right? The response is not equal. This battered spouse syndrome is to help explain how somebody might subjectively view something different than somebody else. She partly disagrees because objective things happen leading to subjective thoughts. So they're trying to say basically it's all in her head. Sarah Boone would make this decision for this. It's not like an objective, you can verify it type thing. She says, well, the things leading up to it you can verify as objective. They ask if she is familiar with justified use of force instruction given to the jury. She's not a lawyer, so she's aware but can't debate finer points. There is a subjective component if someone believes they need to use deadly force or non-deadly force. You agree? I do. There's a second component that is objectively reasonable the ordinary person to use force, correct? She says, I understand what you were saying, correct. Basically what they're saying is, so it's subjective if you believe you need to use force, but there's it also has to be objectively objectively a response an ordinary person would do given that subjective component. At least that's my understanding. Originally, battered spouse was to explain why someone stays in these relationships. It isn't intuitive to someone who doesn't understand these things why they would stay in the relationship. So basically, battered spouse is something that's old, and they're saying the original intention was just to explain why you would stay in a relationship other people thought you would leave. It didn't originally have this use, right? And which is what they kind of are going for there. If the law changes when it comes to a requirement to withdraw from a situation, that can change some of these things. Objection, there's a withdrawal. The question about withdrawal. So they're trying to say, well, maybe, what counts changes with the laws. Would you agree that hypothetically, if someone is running down their partner, hurting their feelings, it might be an element of a verbally abusive relationship? It could. Propping one up, saying, I'm the best thing ever happened to you, you will never do better than me, is that a potential component element of control in an abusive relationship that might be used by an abusive partner? Yes, to encourage a partner to not leave. He's listing off things Sarah did. Considering gifts, if you give someone a gift but consider it still be yours, is that a form of control? He uses the example of a bike, the bike that Sarah gave George but then also said it was hers. I don't think that there's strong evidence of that. It does happen, but not specific to this. How about keeping control of birth certificate or identification? It happens. I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he can allow you to in a bit. Hypothetically, if one partner destroys the belongings of another partner, is it a potential example of exerting control in a relationship? Yes. Is threatening to use legal processes against your legal partner an example of controlling your partner? Do X, Y, or Z, or I'm going to have you arrested. Yes, I agree that happens. That's something they said Sarah Boone did. Back to the 3-part cycle. Just one of those cycles can be enough to get you traumatized. Sarah described her first date, correct? Yes. Not financially intertwined. Yes. No children, correct. Not living together, correct. After this description, which included him smashing her phone, correct? Yes. Hitting her for the first time in her life, yes. Making her crouch for hours that her back hurts, yes. Threatened to sodomize her, correct. And she was all bruised up, correct. First time she had met him, correct. And after this, there was a second date? Yes. Without any of the intertwinement, correct. That one day, theoretically, could be the cycle. Yes. And he says, but this is different than, he described a married couple, I think it was together like 24 years, have kids in a house, they've been living together. She says, different intertwinement, but the pattern can be the same. Of course, there's many reasons you might stay in a relationship someone on the outside would consider abusive, correct. The defendant described that she felt like she was making Mr. Torres a better person. Yes. A better father. Yes. A better ex-husband. Yes. With phone calls. Make sure he calls his children. Yes. Send the kids Christmas gifts. Yes. Send his ex-wife money. Yes. Would that indicate Miss Boone wasn't financially reliant on Mr. Torres? She is saying spend your money elsewhere. No. Because even if money was needed by Miss Boone, her tendency, even if she needed it, would be to make sure that he was spending it in a way to make him look better. Even if she needed the money, something like that. In her perspective, Mr. Torres needed her to make him a better person. I believe that. How many years of her adult life did she describe working? And this is where things come the way I thought they would. She didn't give a quantity. She just went through a variety of jobs. She had been 18 for 24 years when you met her. Did her work history make up 24 years? Doesn't know. She wasn't working at the time of the incident, and she was living off the settlement with her ex-husband. It was a lump sum plus $1,000 a month in alimony and $100 in child support. Yes, it was Mr. Torres who would work. He worked at Ace Hardware when he would show up. Sometimes he didn't show up due to his drinking problem, correct. So Sarah is, they're pushing that maybe Sarah wasn't financially reliant on George Torres due to Mr. Torres. She needed George Torres because she's lazy. That's what I feel they're trying to go with. That maybe Mr. Torres was being financially abused by Sarah. And remember, Sarah at some point said he was taken off the lease and made just a tenant. I feel like that's going to come into play later, that maybe that was a move by Sarah to control him more. Sarah described to you one instance where violence occurred in front of her child and her child reported it at the school. Correct, yes. Teachers are mandatory reporters, correct? That's right. Did you review any DCFS records in this case? Didn't receive any. So that makes me question, is that story even true? If the teachers are mandatory reporters, did this happen, or is Sarah saying it to make herself look better? Or more look like a victim? Did she indicate she was too afraid to have her son come over to the house? There were times she asked Brian to not bring her son over. And Mr. Boone was aware because she would say things like this, correct? Yes. And she would escape to Mr. Boone's house to escape violence, correct? Yes. Again, that leads to the question I would think of, why didn't she leave when he was in the suitcase and he couldn't get out? She called Brian. She could have told Brian to pick her up. But she went to sleep. On the 24th, the child was scheduled to be picked up by Sarah, despite what both her and Brian knew. Correct, yes. And she swore on the life of her son she was telling the truth, correct? Yes. Owens objects, objection sustained. We heard it. She swore in the interrogation on her son's life that she was telling the truth, and we know she was lying. She swore on her son's life it wasn't intentional. She killed Mr. Owens. Owens objects, objection sustained, stricken. She quote unquote swore on our child's life that it was not intentional, correct? Witness once directed to her saying that, and they just struck it. They just dropped it. It's basically the witness knows, right? She just doesn't want to admit it without being forced to admit it. She's hoping. To me personally, the witness seems extremely biased and was hoping for another objection from Owens to get it stopped again, and the state expected it and just gave up. Some of her diagnoses predated her relationship with George Torres. When diagnoses predate violent partner relationship, there is an independent cause that may later contribute to the phenomenon you see. Witness says she doesn't agree that there always have to be an independent cause in all cases. So they said, well, let's talk about Sarah's case. She was bringing things with her. She had issues prior to Mr. Torres, correct? She had to remind her of these are all yes or no. The woman doesn't like yes or no's, right? I don't think anyone would in this instance, but she doesn't want to do them. She reviewed some Advent health records and Aspired records, something like that. I don't know exact wording. It's 2 health groups. There were records of Sarah coming and leaving without treatment, some of them. There was a time she goes and she's described as having ETOH on board. That means she'd been drinking. Sarah comes with complaints of depression in 2018. Alcohol is a central nervous depressant, correct? Yes. And I had someone one time say, well, alcohol doesn't make you depressed. So I misunderstood when I brought that part up. Alcohol can increase feelings of depression. You are familiar generally with effect ethanol has on the body. Yes. She knows what diagnosis is. She knows what diagnosis alcohol abuse disorder. Yes. She's familiar with the standard. She's familiar with the alcohol abuse disorder diagnosis. She's familiar with the standard size of drinks. It might be asked during evaluation what it was exactly. For example, how big is a glass of wine, but she doesn't know like the ounce standard size of a drink. Sarah had a blood alcohol of 1.65 when crying of depression. In November, when found stumbling by police, she had a blood alcohol of 0.85, correct? And this is very interesting. This is another one where I think the witness is purposefully trying to fight the state because she's biased. Witness doesn't like the use of the word stumbling. They approach the witness with the records and ask her to read the line. Owens wants her to read the full paragraph. Approached. She says no with how the question was phrased, and they make her admit that it says she was stumbling. The word stumbling is on the page, and she doesn't want to admit it. If I was a jury, if I didn't think she was biased before, it's in the record, she knows it's there, and she's fighting it because she doesn't want Sarah to look bad, and she's supposed to be an expert, I'm supposed to trust her, I'm worried, right? I'm worried at this point if I'm the defense. When she spoke about those events, she confused them and combined two. No, she said she had 2 Baker Acts. That's involuntary holds, I believe. Defense asked, did she describe the date in June? Something about June. I don't remember as June. They have her check the notes. She described it as June going to find a pastor and then going to a lakeside den. Then she talked about violence of George driving her roughly in the car. These are 2 instances, correct? Yes. She went in January because she was sad about her husband being out of town with no mention of George, correct? She digs through the notes. The hospital are not referencing her relationship with George on that day. So it sounds like she's combining multiple past instances together and her memory is not matching reality, not matching health records. One of the conversations with Sarah Boone is about being dragged down the night before the event. You reviewed the photos of Miss Boone from the case. Was there evidence consistent with that? She said there's no indications on her outward body, but she didn't see her scalp. She didn't see specific injuries. Alcohol can impair giving history. Narcissistic personality disorder is brought up. There's 9 traits. Grandiose sense of self-worth, preoccupied with fantasies of unlimited success, power, or beauty, believe that you're special and should only associate with other special people, requires excess admiration, sense of entitlement and unreasonable expectations for special treatment, interpersonally exploitive to get their own ends, lacks empathy or identify with feelings of others, envious of others or thinks others are envious of them, shows arrogant behaviors or attitudes, and she agrees. And you believe she has traits of that disorder? Yes. So he says, grandiose sense of self-worth? Yes, Sarah Boone has that. Preoccupied with fantasies of unlimited power, beauty, or the unlimited power one? No. They asked if she remembers going to the state's attorney's office on October 1st, 2024, and giving a deposition and swearing to tell the truth. Yes, they made her look up her own statement then, and then in her statement, she said that Sarah Boone is preoccupied with fantasies of unlimited power, success, or beauty. She changed, the expert changed her story from testimony, literally from earlier this month. Again, I'm on that jury, and I'm supposed to trust her. In your estimation, does she believe she is special and can only associate with other high status people? No. She does not require excess admiration. Does she have a sense of entitlement? Yes. She's not interpersonally exploitative? With lack of empathy, you said that might be the case, but it's not intentional, correct? And she said she isn't aware she's inconveniencing others. So basically, Sarah doesn't have empathy and doesn't know it. That's not looking good for Sarah. So there are 3 of those traits, not the 5 that were required. Yes, cheating to her means looking at porn, not sexual intercourse with other women. She did not see the phone extraction text messages. So the witness did not see phone extraction text messages. Some of the traits for abusers could include control, jealousy, easily angered. What other traits? Segregating victims, coercive control, using emotional expressions like rage. When they go through what she went through, it's a lot of evidence that we have seen. Anything he didn't mention, it's not covered. So basically, it's like, did you see anything I didn't mention? And she's looking through her notes. She interviewed a Melissa Sexton, interviewed nobody else, didn't see text messages, no jail records, approach, objections sustained in part, overruled in part. You testified earlier that you relied on diagnoses by other experts, correct? She said, I use it to form my opinion. I can use it to form my opinion, not that she did. You didn't review text messages or phone call other than 911. Talking of the 23rd version, this is Sarah's version of what Sarah told her happened on the day of George Torres' death. Not doing anything, a Sunday. Did chores, and as a reward, they could rest after the chores. She told her that her and George didn't start drinking till around 4 p.m. She's checking her notes. She's seen evidence, including receipts, including a bottle of wine at 12:17 p.m. that day. She didn't question about the inconsistency of buying it but not drinking until 4 p.m. Sarah mentioned at some point they had unfinished wine they drank. She knows about the 2 bottles purchased. She knows Sarah weighed about 100 pounds and George was 103 at the time. Was the alcohol consumption taken into account? Yes, Sarah did not describe herself as intoxicated. Hypothetically, if she told the jury she was intoxicated, would that change your opinion? No, because that was also the witness's opinion. Did she indicate that day there was any point in time she didn't remember? Yes, she did not remember taking the videos of the suitcase until she was at the interrogation room and they went through them. When asked about her specifically, saying she didn't remember certain points, she can't recall. Hypothetically, if she told the jury she can't remember 9 minutes prior to the first video, would that be inconsistent with what she told you? No. Well, didn't she indicate to you she didn't forget any part of the night, right? Right, she didn't say that. So basically, Sarah told this woman she didn't forget anything. And later, she changed her story when they found the videos. So she's saying, this is where I kind of was like, with witness, I'm kind of confused. The witness is saying it's not inconsistent that Sarah is saying she doesn't remember 9 minutes when she told this woman she remembered everything. I don't understand. And the reason she kind of gives of this, if you didn't remember 10 minutes prior to the video, would that change your opinion? And she goes, not really, because the course of events went over several hours and it's usable for people to not remember every minute unless they've got a photographic memory. She's trying to play it off, right? But because I'm not asking about hours, I'm asking about the 20 minutes, particularly of the offense. Does that affect your opinion? No. She told you the day had been going well. Yes. Conflict free. Yes. She said it was a good day. Hide and seek happened. She went for the shower, came down. Mr. Torres was in the suitcase. Yes. Then she zipped it. Did she say how it was zipped? She just said it wasn't zipped all the way. It was still funny at first. Correct. But Mr. Torres got mad, which made her mad. Mr. Torres was saying, I can't breathe. Is that what she says that's what's on the video, but that's not what he's asking. He's asking, what did Sarah tell you? So on the video, he can't breathe, but what did Sarah tell you? You're the expert. You're the one making this decision. At the time, she said she was saying something he was saying was making her mad, but not the extent of that. So Sarah didn't say he couldn't breathe. Sarah said he made her mad with what he said. You didn't find it important to find out what he said specifically? She doesn't agree. She said she didn't find it important. Why didn't you ask? She doesn't agree that she didn't find it important. Well, why didn't you ask? She allowed open-ended discussion, and it isn't an interrogation on the first visit. And this is where the expert loses me again. You had 9 minutes to ask her, 9 visits to ask her. Did you ever ask her specifically? No. And it wasn't him doing something. It was just words. Yeah. So she had 9 visits and never asked what he said. But her defense was, well, I wouldn't ask that on the first visit. When she was mad, she said she was going to leave him in there for 2 minutes, correct? Yes. So he understands what it's like to be choked. Yes. Did you ask why she didn't let him out after 2 minutes? She thought he could get out himself. She said when she unzipped it, it was easy. You reviewed the still photo of the suitcase and videos. Yes. Do you understand the metadata? I believe I reviewed it. You would agree 20 minutes is 10 times longer than 2 minutes. I would. If Mr. Torres couldn't get out in 20 minutes, she indicated she would let him out, correct? She did not. She described herself as helpful to the police. Yes. Do you agree? Yes. Do you think lying to the police is helpful? No. Was she being truthful to the police? Was she not being truthful to the police? I would agree with that. So Sarah thought she was helpful. The witness thought she was helpful. But lying to the police isn't helpful. And she was lying to the police. She described when getting him out as stretching his little legs, correct? Yes. No physical fighting, just wanted him to be uncomfortable. She said she poked him with the bat. She reviewed the autopsy report and photos. She questioned how he used. Did you question how he used she used the bat? No question about the contrast of the autopsy photos. Objection. Approach. Give me 1 second here. I had to cut it. There was some banging outside. I need to figure who was outside the house. Let's see, where was I at? She questioned how she used the bat. No questions about that in contrast to the autopsy photos, and there was an approach. Did she say she used the bat at all? That she used the bat when it was inside. So she only used the bat when he was inside the suitcase. Correct. She said she flipped the suitcase upside down. Yes. Did she mention a call to Mr. Torres' brother? No. So she didn't mention that call to the brother, which is interesting because the idea of like yelling in the background of a call was something that was brought up as like an abusive thing, and Sarah didn't mention it. This woman appeared to not know about it. She didn't comment about people hearing a loud boom. No. Defenses back up. Abusive partner will use power and control, threatening dogs as an example. Yes. Taking keys, destroying TVs, taking phones, putting holes in the walls are all examples. Not paying rent is a maybe. Violation order of no contact. Yes. And the witness got released. So that right there is their big witness. And I feel like that the state, I don't know, people probably disagree. I think the state did a good job, if nothing else, making her appear extremely biased, and that maybe because we're not following an objective criteria list, and if this whole defense is on this one woman, maybe the woman's, saying things that aren't there. I think the prosecution did a good job at that part, getting that across. I think they could have done better, maybe. I don't think the constant objections from the defense is going to help opinions. Of course, when the judge is like, when we strike it, you can't consider it. Okay, but there was a similar question after, so I don't know. I wouldn't have if I was the defense, I wouldn't have brought up the dog angle. They really wanted to use this dog angle. I can tell he did that, but there's no evidence of him being abusive with the pets. They presented no evidence other than Sarah says it, and the photos show the photos apparently show him and the dogs getting along. If they had evidence of him abusing the dogs, I would expect it to be out there, but they aren't. They're just saying he is. So it feels more like a character assassination attempt, which now the witness is describing something involving, at one point, shocking dogs, and that's why they know about this thing. I don't think it flies. I don't think it helps. But there's a break, and we're coming back. And we return for the final part of the day. They actually ended by about 5. Defense has copies of no contact orders, but the state has not seen them. Both are from 2019. They are relevant due to Dr. Harper's testimony, elements of control. The state says it's fine, but just because an expert relies on them doesn't mean they are admissible. And it isn't a fact in dispute that this happened, it's just irrelevant hearsay in this form of a document. Defense says no hearsay, it's an order of the court. Shows control. Defense says they expect the state to say Sarah Boone was asserting control. The judge explains that because of case law, this is hearsay. He says the defense says one exception is business records as an exception for hearsay. He thinks it's probative. State says it will come in. There's body-worn camera of Mr. Torres saying, well, she said I can come. Sounds like the state wants to use that. The objection is to the actual paper. Judge says it's relevant, but hearsay due to case law, and then reads it. It's not accepted. Objection sustained. But things continue. Owen talked to someone in the building who sent a message before the hurricane. They need to follow up on a subpoena. So basically, from my understanding, there's two issues. Is this introduced correctly? Is this allowed? The state's saying we're fine with it being introduced. We don't agree with the evidence. It's hearsay. The judge is saying he doesn't agree with either right now, and it's hearsay. That's what I was getting. Maybe I'm wrong. I was trying to hear it, trying to understand. So the defense wants to get a records custodian to follow up on the subpoena. The state says they don't need to make an employee do it because his argument is that it's hearsay and slippery slope for her medical records, not that it's, not really that document. State then withdrew the hearsay objection after a little back and forth, and it sounds like they did it basically so a poor employee doesn't have to get involved in the Sarah Boone trial. So they're going to allow the documents in. Basically, the defense just made it annoying enough the state allowed it. That's my takeaway. Defense wants to rest tonight, but in the morning, they need time to talk to Sarah Boone and explain why they think they should rest and not call more witnesses and introduce more evidence. They need time. So basically, it sounds like Sarah Boone might not be in agreement that they don't need more witnesses and might not be in agreement that they don't need to have more evidence. Like, remember, there were other people that we thought would be coming back, like Brian Boone. It is possible that Sarah doesn't like how little the witnesses were, or she might not like how the witnesses that were called were not useful. I talked about that earlier. And that's okay. They can talk to Sarah Boone. They talk about the rebuttal. The state thinks it'll take about 30 minutes for Dr. Harper. Defense says about 30 for the cross. 2 hours of video from body cams and the phones. We're going to have 2 hours of video tomorrow from the state. My fingers are killing me already just thinking about it. And then they're going to read phone messages. Again, fingers are killing me. Talk of jury instructions, and Owen seems confused about the battered spouse instruction, how it will be done. It wasn't very clear. They will see how long rebuttal takes, and closing might take until Friday. Defense has to provide the instructions they want. State wants to add a jury instruction about Miranda and that the police don't have to read the final line, but it can be taken into consideration. We've talked about this many times. Sarah was then explained to by the judge that that when the jury looks at Sarah Boone's statements, they have to consider voluntariness. Basically, law enforcement doesn't have to ask if a suspect wants to keep talking, but it can be considered when considering if a statement was voluntary. They want to add that to the jury instructions. Do you understand? She says yes. Sarah hasn't had conversations with her team about any of this yet, so they're coming back tomorrow. Hopefully I combine all this together, right? I know there's a really short clip in there from where I had to cut it out. So basically, I think Sarah Boone's defense, I think Dr. Harper sounded better at the start. I think as soon as the prosecution got a hold of her, it went bad. I think that the fact that they are looking at going after her again in rebuttal, the fact that they're going to have 2 hours of video, the fact that they have text messages and she's never seen these text messages, I think the state thinks they can make a pattern, and the defense thinks it too, that Sarah Boone is the abuser. Sarah Boone was the controlling one. That in the relationship, while there was abuse both ways, Sarah Boone maybe was the primary aggressor. She was the one who was, the main person. And that led to her, the main aggressor, murdering a man. Not battered spouse. I think that's going to be the state's argument. But we'll see. we'll see. All I know is I am tired. I got to get water. My throat is killing me. I'm excited for tomorrow. I don't know. I expected more from the expert. But like, I feel like the expert was a letdown for Sarah Boone. I feel like the expert, as time went on, the biases were showing, and I don't know. And the thing is, at the end of the day, and the defense is very clear on this. They understand. You got to get past the fact that Sarah Boone is Sarah Boone. People are going to have opinions about Sarah Boone as a person, her attitude in general. She's not likable. Let me know in the comments what you think. Like, comment, subscribe, and see you next time.